And it was the Republican Party that ignored the Constitution, did not allow him to have a vote, did not allow him to come before this body, did not uphold their advise and consent oath and their advise and consent. So I just wanted the record corrected. It wasn't 2 nominees, it was 3. The third one was not heard because for the first time in the history of the United States, the Senate refused to hold a hearing, refused to have a vote. Now, Senator Feinstein talked about the dark days before Roe versus Wade. I have some experience with that. We have 2 cases in Vermont, Leahy versus Beecham and Leahy versus Bartlett. I'll tell you very briefly about it. Leahy versus Beecham was a case that, in fact, I brought a declaratory judgment before Roe versus Wade, before the Vermont Supreme Court. I organized that case so that the Vermont Supreme Court, a very conservative court, could rule on the constitutionality of our anti-abortion statute in Vermont. They came out with a decision, basically what Roe versus Wade did. This conservative 5-member Vermont Supreme Court in Leahy versus Beecham. Leahy versus Bartlett was a case where I prosecuted somebody procuring abortions. And these are the dark days that I don't want to go back to. I got a call from the police at 3 o'clock in the morning. I was state's attorney at the time. I went to the emergency room at our local hospital. A young co-ed nearly died from bleeding from a botched abortion. At that time, it was illegal. We found out the person who had procured them. He had done this with a number of people. He would then blackmail them for either sex or money. And when I brought it to trial, we found the person doing the abortion was from Montreal. They said they'd go to trial figuring she'd never appear for the case. She was there. 2 Royal Canadian Mounties escorted her. And I pointed out to the defense attorney, the evidence would show she was trained to do these abortions, working for the SS at Auschwitz, so she could abort the women prisoners that they had impregnated, so that they could keep on using this women that way before they put them in the gas chambers. He looked at the names of the people who would be the potential jurors. They sought a plea. Now, on another, so I applaud the senior senator from California for raising the issue she did. Yesterday, I asked about your connections to billionaire super donor Philip Anschutz. In his role, his very extensive role in lobbying the White House to get you on the 10th Circuit. And once on the court, you said you recused yourself from cases involving him, and I commend you for that. You did the right thing. But you wrote in your Senate questionnaire that you currently follow a recusal standard broader than what is required by the Supreme Court. And if confirmed, you'd follow the weaker Supreme Court standard. Does that mean, if confirmed, you would no longer recuse yourself from cases involving Mr. Anschutz?
Senator, what it means is I will, if I'm fortunate enough to be confirmed, go through the same process I did when I became a judge on the 10th Circuit, and which I committed to do at that time, which was look at the applicable law, look at the facts. I had a law clerk. I don't know if he's somewhere around here.
Well, no, but let me get back to this. You found the facts were such that you recused yourself.
Yes.
With Mr. Anschutz when you were on the
Yes.
Court of Appeals.
Yes.
If he had a case before the U.S. Supreme Court, would not the facts be the same?
He is a former client, and I treated him as I treated my former clients, large and small. And Senator, I'd have to look at the recusal standards that are applicable to Supreme Court justices.
Well, the federal recusal standards apply to both Supreme Court justices and other judges.
Yeah.
But the only difference is, of course, Supreme Court, whether they recuse themselves or not, that's not reviewable. But would you, again, you found enough reason to recuse yourself from the circuit, and I applaud you for that. Would not those same reasons apply to the Supreme Court?
And Senator, I just have to study the law and the practice of the court, just as I did when I came on the 10th Circuit, and I commit to you the same process and the same integrity of the process. You look at the law, you look at the practice of your colleagues, you consult with your colleagues. That's what I did. I had a law clerk prepare an extensive memorandum for me in which he analyzed all of the relevant precedents, the practices of my colleagues, and
I would note that
the facts.
The federal recusal standard, as far as studying the law, it's the same law for the Court of Appeals and the Supreme Court, with one exception. The Supreme Court's not reviewable. Now, I asked you yesterday whether there was any circumstance in which the president has the power to authorize torture or surveillance in violation of laws passed by Congress. You answered, I thought, correctly, no man is above the law. Now, I'm sure President Bush and his lawyers believed he was operating within the law when he authorized torture and warrantless surveillance, but they still thought they could violate a statute if they're exercising their Article II power. Is there any circumstance where a president could ignore a statute passed by Congress, signed into law, and still authorize torture or warrantless surveillance? If you had a statute against torture and warrantless surveillance, is there any circumstance in which a president could ignore that statute?
Well, Senator, I don't want to deal with a case that might come before me, and those are the sorts of things that could come before me. But I can speak generally, and I'm happy to.
Go ahead.
Presidents make all sorts of arguments about inherent authority. They do. And that's why we have courts to decide. Presidents of both parties have made arguments, for instance, about the War Powers Act. Both parties. And the Congress has taken a different position on that matter, for example, with both parties. And the fact is, we have courts to decide these cases for a reason, to resolve these disputes. And I would approach it as a judge through the lens of the Youngstown analysis.
Have you thought of a case where a court has said a president could ignore a law that was on the books?
Senator, sitting
Can you
here,
think of one offhand?
I can't think of one offhand,
Thank you.
Senator.
Neither can I.
Yeah.
Now, the architect of President Trump's Muslim ban has declared that there's no such thing as judicial supremacy. And the powers of the president to protect our country, quote, are very substantial and will not be questioned. It was felt that he was signaling that the president could ignore judicial orders. Any president, do they have to comply with a court order? Assuming, I mean, obviously they could appeal one, but assuming it's been upheld, do they have to apply, do they have to comply with it?
That's the rule of law in this country, Senator Leahy. And presidents for a long time have said all sorts of things like that. President Jefferson said things like that.
Well, we're not,
President
he was slightly before my time.
But presidents say these things, right? Congress says things, and then judges decide. And that's the way our system works. And, Senator, all I can commit to you again is I'm a judge now. I take that seriously. And you better believe I expect judicial decrees to be obeyed. As I said yesterday, a wise old judge who you're going to hear from tomorrow, one of my heroes, says the real test of the rule of law is where a government can lose in its own courts and accept those judgments.
Well, I believe in the rule of law, too, and that's why I've stayed on this committee for decades.
I know.
When I took my oath before the Vermont Supreme Court, when I was sworn into the bar, I took that very seriously. I did with our Second Circuit Court of Appeals and our federal courts, and when I was sworn into the U.S. Supreme Court bar, I took that very seriously. I believe that ultimately we are a country of laws, and we should follow them. Now, speaking of which, yesterday we discussed the relevance, what our framers meant in the Constitution. And many feel they want to prevent a president from being corrupted by foreign governments. Obviously, I'm referring to the Emoluments Clause. What is the purpose of the Emolument Clause?
The Emoluments Clause, Senator, is not a clause that had attracted a lot of attention until recently.
Well, Governor Randolph of the 1787 Constitutional Convention pointed it out. I mean, you want to go back to Jefferson, I'll go back to Randolph.
Hey, I'm with you. Among other things, it prohibits members of the government of this country from taking emoluments, gifts from foreign agents. And the question is, what exactly does that mean? That is a subject on which there is ongoing litigation right now, Senator, I believe, certainly threatened litigation, impending litigation. And I have to be very careful about expressing any views.
Well, what Randolph said, it was done in order to exclude corruption and foreign influence, to prohibit anyone in office from receiving or holding any emoluments in foreign states. Now, you're hesitant to discuss it. You wouldn't be hesitant to discuss the Fourth Amendment or the Fifth Amendment, would you?
Well, I'm hesitant to discuss any part of the Constitution to the extent we're talking about a case that's likely to come before a court, pending or impending. And I do think that the Emoluments Clause has sat in a rather dusty corner for a long time until recent headlines, and I know that there are cases that are at least impending in that area. I'd be happy to try and talk about things that aren't likely to come before me, but
let me ask you this. Then what does the Constitution say a president must do if he or she receives a foreign emolument?
Well, Senator, that's a good question. I don't believe it's been fully resolved.
Well, I thought it's kind of easy. The clause prohibits receipt of any emolument without the consent of the Congress.
Right.
Now, you're a judge. I'm, as I said yesterday, a lawyer from a small town in Vermont. But if it says they cannot receive any emolument without the consent of the Congress, isn't the answer pretty simple? What a president must do if he or she receives a foreign emolument, they have to get the consent of the Congress.
Sure. I thought you were asking what would be the remedy if they violated. And
No, I'm asking what they have to do.
No, you're absolutely correct. Of course, Senator.
I appreciate that.
Well, no, I think you've read the clip.
Because I understand your concern, and I appreciate it as a judge.
I know you do.
Answering questions about any pending litigation. But you have been very hesitant to even talk about various Supreme Court precedents. I know that Chief Justice Roberts, when he was before us, he said he agreed with Griswold and Brown. Justice Alito said he agreed with Hamdi and Eisenstadt. So we've had justices nominated by Republican presidents who have been willing to discuss past precedent. I was just kind of hoping you'd be as transparent as these prior nominees were. During the campaign, President Trump promised to appoint judges very much in the mode of Justice Scalia. Now, he had every right to say what he wanted. He could have picked anybody. The vice president said you two are cut from the same cloth. But Justice Scalia is a friend of mine, is an intelligent, influential jurist. I voted for him, in case people wonder, and not just because we both have Italian ancestry, but his interpretation of the protections afforded by the Constitution left our most vulnerable communities out. Do you agree with Justice Scalia's characterization of the Voting Rights Act as a perpetuation of racial entitlement.
Senator, the Voting Rights Act was passed by this body during the Civil Rights era in order to protect the civil rights.
Well, it was also updated just a few years ago during President George W. Bush's tenure.
2006, it was reauthorized with the support of the president. That's right. That is true. And it is designed to protect the civil rights of Americans.
But do you agree with Justice Scalia's characterization of it as a perpetuation of racial entitlement?
Senator, I don't speak for Justice Scalia. I speak for myself.
Okay, accept that. Others who, there's a lot of people who in the administration have described who you are. One of the reasons we have these hearings is so the American people and this committee can determine better who you are. And that's why I made it very clear I'll be here at the hearing and make that determination. Because I was concerned, I knew that Steve Bannon was a strong advocate for your selection. And with all due regard to Mr. Bannon, he's well known for giving a platform to extremists and misogynists and racists. At the CPAC conference a few weeks ago, both Mr. Bannon and Reince Priebus praised your nomination, and I'd ask consent that a report of that be included in the record.
Without objection, your article will be entered.
And Mr. Priebus said you have the vision of Donald Trump, and by nominating you, Donald Trump was talking about a change of potentially 40 years of law. Suggesting you're coming there as a Trojan horse. What vision do you share with President Trump?
Senator, I mean no disrespect to any other person in saying they don't speak for me, and I don't speak for them. I have great admiration for Justice Scalia, as we've talked about. I have admiration for every member of this committee, for the President of the United States, for the Vice President of the United States. But respectfully, none of you speaks for me. I speak for me.
Okay.
I am a judge. I am independent. I make up my own mind.
Well, the reason I asked, Mr. Bannon, Mr. Priebus, and the President had closed-door interviews with you. And in these things, including this material I've just put in the record, they promised their donors a nominee that would bring a pro-corporate, socially conservative agenda to the court. Are you saying they're speaking for themselves, not for you?
I am.
Thank you. In your view, in the Constitution, it speaks about high crimes and misdemeanors. What kind of conduct does that include?
Well, Senator,
We've talked about the founders. They put that in. So
I think, classically we've talked about felonies. It has been typically what this body has impeached individuals for. There have been a variety of cases involving, sadly, federal judges, as well as presidents, as well as justice attempt. And usually it's been more along the high crimes rather than the misdemeanors.
I would assume that you would not think of a misdemeanor in the sense that we have like traffic violations, going through a stop sign or something like that. That's a misdemeanor. Would you accept that that's probably not what it's meant in the high crimes and misdemeanors?
I would not want to issue an opinion on that without the full judicial process, Senator.
All righty.
I don't know. I know misdemeanors in 1789 looked a lot different than misdemeanors today. We have a lot more criminal law today. and a lot more misdemeanors today than we did back then. I can say that.
I'm going to start driving more carefully. Thank you, Mr. Chairman.
Senator Hatch.
Judge, I've only been around here 40 years, and I've seen an awful lot of great people in the law come before this committee. And I haven't seen anybody any better than you.
Can't hear him.
I'm very proud of.
Can you
Go ahead.
talk louder?
You have to, the mic is not carrying you. Or,
I'm very proud of you and the service that you're giving to our country. There's no question that any fair observer would say how lucky we are to have you nominated by whoever to be a justice on the Supreme Court of the United States of America. I held the highest rating an attorney could have when I was a partner in a Pittsburgh law firm. In Utah, I held the Martindale-Hubbell AV rating. These are ratings, as you know, given by your peers without your knowledge. And I have to say that I've been around here 40 years, and I've seen all kinds of judges come before this committee. And there have been a number of great ones. And you, sir, are one of the great ones. And I'm proud of you. But I knew that before you came here to testify.